Good morning, ladies and gentlemen. Thank you very much for your time and attention. I'm sorry my summer cold's got me wearing a mask so I don't spread my summer cold with everybody. I want to share my words, not my summer cold, with you. As you know, as we started out, my client, Kaliyha Everett, is not guilty. That hasn't changed despite the state's argument. And unlike the many versions of the events of what happened on the 30th of December of 2015, that will not change. As the judge instructed you, there are 3 places within this trial for you to confirm your reasonable doubts: the evidence, the conflicts in the evidence, and the lack of evidence. There's absolutely no evidence whatsoever, no objective scientific evidence placing my client at the scene of that shooting. None. It's also undisputed that 2 of the eyewitnesses intentionally lied to law enforcement in sworn statements. Intentionally lied. I anticipate there will be argument that those lies were explainable and they eventually came clean, but we know that that's not true. We know that it wasn't until yesterday, 5.5 years later, that Andre Smith actually admitted that he had been the one to move that black backpack. It is also undisputed that every single identification of my client, Mr. Everett, was tainted. The photographs were shown so that a person would recognize someone they'd seen before. Mr. Smith had seen Mr. Everett in the apartment complex. Remember, we went through all of the photographs. All those 5 other people, he'd never seen them before. But he'd seen Mr. Everett before, and he'd seen him before the 30th of December of 2015. Now, he says that he told the police that, but they never wrote it down, and he never wrote it down. I submit to you that he chose not to tell the police that. This is the same Mr. Smith who testified yesterday that he was 23 years old, and 5.5 years ago he was 15 to 16 years old. Now, maybe he's not good at subtraction, but I submit to you that that goes to his credibility. And the assertion by the government that he closed his eyes and picked out a person randomly is not the evidence that we have. He picked out the only person in that photo pack that he was familiar with. And we know that the photograph that Miss Major received via email was not something that she just found. The government's argument and opening argument yesterday morning, and we heard it again today, that she found it. She did not find it. Someone sent it to her. We don't know what was attached to that photograph. We don't know how that person got that photograph. We don't know any of the details of what she was told about that photograph. She didn't just find it. She never identified anything about my client, Mr. Everett, that would distinguish him from any other black male in that photograph. She said something about a teardrop tattoo, and you'll get a chance to look at all the pictures. Mr. Everett, you saw him. He doesn't have a teardrop tattoo. We also know that there's evidence of procedural irregularity within what law enforcement did, within the scene. We know that there was a shoe that was in one location. It was moved. It was moved back before it was photographed. And we know that there are 4 different people's DNA on that shoe. So much so that Miss O'Neill testified that she can't identify any one of those people's DNA. We know that when Mr. Lateris Matei looked at the photographs, that there was someone else in the room with him, encouraging him. despite the fact that he was an adult. There was another adult in the room with him. Deputy Goff told you, looking at both of these photo packs, I'm looking at, right now at State's Exhibit 3, Deputy Goff told you that this person identification part of that document that says Hillsborough County Sheriff's Office photo or live lineup sequence form at the top, at the bottom, has Kaliyha Everett's name on it. That one's from photo pack States 3 that was shown to Andre Smith, as well as photo pack States 5 that was shown to Mr. Mattei. What Detective Goff told you is that the person who creates the photo pack is the one that put the name and the identification information on the bottom. He told you he got the photographs and everything else in the photo pack from the person who created it. So the state's argument that it's not coincidence that they all identified him, absolutely it's not coincidence they identified him. His name's right there. It was put there in a photo pack that was shown to a guy he went to school with. Now, Detective Perez may not have been the one who showed the photo pack, but he put Kaliyha Everett's name on there. Talk about conflicts in the evidence, the multiple conflicting descriptions of the shooter. They don't match one another, as well as they conflict with those witnesses' own testimony. The conflicts inherently created by the bias of those individuals. Maybe they didn't intend it, but unconscious bias exists. Certainly, Mr. Mattei didn't want to be charged with anything. His initial description of the shooter was camouflage shorts, but later he changed it to khaki pants. Those are two distinctly different garments. He changed that description knowing that law enforcement were going to find a pair of khaki pants outside of his sister's house. We know Mr. Mattei was shown photographs with another adult in the room influencing him. We know there's no reason for another adult to be in the room with him. And let's talk about those descriptions. Okay, we've got a description by Miss Major. Her first description of the shooter is a black male with a do-rag and black jeans. Her second description is a black male with black jeans and a teardrop tattoo. Then she gets a photograph in the email of my client wearing camouflage shorts. And 5.5 years later, yesterday, she came in and testified. There was a black male wearing khaki pants. And a beanie. Let's talk about Mr. Smith. His first description in 2015 was a black male with a do-rag, wearing black jeans. His second description is a black male wearing black jeans. Five and a half years later, in trial, his description in 2021 is a black male with khaki pants. And a beanie. Mr. Matei, in 2016, his first description is camo shorts. Then he changed it after he sent the police to his sister's house to pick up some items outside of his sister's house, to khaki pants and a beanie. Now think about those changes. Think about what Miss Major told you. She told you that Detective Messer told her about parts of the investigation. She told you that Detective Messer told her that Mr. Donaldson's water bottle had been located. Why did those descriptions change? Because by 2021, there was a pair of khaki pants that had been located, that had been analyzed and tested. There was a beanie hat that had been located, analyzed and tested, and cannot be verified as ever having been touched or worn by my client. But certainly not the do-rag that both of these individuals initially testified about, and absolutely not the black jeans that they testified about under oath, gave sworn statements to law enforcement back close to the time of the incident. Those descriptions do not match Kaliyha Everett. We certainly know that Mr. Bell knew Mr. Matei. We know that Mr. Bell wasn't talked to until February of 2016. We know that Mr. Bell hung out in St. James Apartments. And we know that Mr. Matei lived in St. James Apartments. It's very reasonable to believe they had contact with one another after Mr. Everett was arrested in Polk County. Neither one of them was arrested or charged. Certainly they had an interest in that, and they had a motive to point the finger at someone else. Now, we don't know who that adult was in the room with Mr. Matei, encouraging him when he selected Mr. Everett's photo. We don't know what that man looked like. We don't know if that was a man with black jeans and a teardrop tattoo. We know Mr. Matei never even tried to identify Mr. Everett in court. We certainly know that Mr. Bell doesn't want to go to jail. He identified those two photographs 5.5 years later when they were sent to him by Mr. Hubbard, when he himself had a pending case that was being prosecuted by Mr. Hubbard's office. He's looking at jail time. Nobody wants to go to jail. Certainly not Mr. Bell. He's out on bond for that charge right now. One of the instructions in the weighing the evidence suggestions that you will receive has to do with whether or not that person has an interest. Certainly that person has an interest. Let's talk about lack of evidence. Now, obviously we don't know what happened to the water bottle with the false bottom. Obviously there's no gun. and no effort whatsoever to try and test for gunshot residue. Now, if law enforcement really believed that those khaki pants and beanie were worn by the shooter, easy to prove. Submit them for gunshot residue testing that the Florida Department of Law Enforcement conducts. No effort whatsoever to do that. There's no location data or any other information from the cell phones of any of those people. There's absolutely no fingerprint evidence we know. Nothing that we know was ever tested. However, remember Detective Thomas yesterday? He told you that he made requests that the car located along the path of travel be tested for prints. He indicated that that piece of paper, the advertisement, be collected because it could be tested for prints. We also have absolutely no idea what Miss O'Neill from the Florida Department of Law Enforcement tested in 2018. She told Miss Dunker that she did a test in 2018, but we don't know what it is. Lack of evidence, ladies and gentlemen. I'm going to the specific jury instructions. And the way that the count 1 and count 2 interact, it's called legally interlocking counts, and you all have a copy of this. But it can be confusing, because the page before you're told to evaluate each case on its own, and then the next case says, but except for these. So essentially at this point in time, what this instruction is telling you is that you are first to consider the evidence applicable to the robbery. Because if there is no robbery, there is no felony murder. And even if you find robbery, it isn't necessarily felony murder. So it's a little bit confusing. Now let's talk about the evidence we have about the robbery. We have 2 eyewitnesses who testified that the subject of the robbery, the marijuana in this case, was sitting in Mr. Mattei's lap when the shooting happened. He got up and ran. There's absolutely no testimony that the shooter, even if you believe it's Mr. Everett, grabbed that marijuana from him. The testimony of Mr. Bell was that when he saw 2 people running, they had nothing in their hands, certainly not a water bottle big enough to have a false bottom. Mr. Mattei, as we know, was never charged with anything. He has plenty of motive to lie about what he got and what he took. He denied that he ever took any marijuana. He denied that he ever saw any marijuana after this. He denied that he took the money, and he tried to deny that he ever had the money, that he had been given the money to conduct the deal. And we know from Mr. Bell that he wouldn't have sent anybody over there to buy if he didn't know that there was money, and that's just common sense. Clearly there was money. So if the marijuana was in Mr. Mattei's lap, outside of the water bottle when the shooting happened, certainly there's no evidence that anybody other than Mr. Mattei was in possession of it. We know that there was marijuana located in the black backpack inside the house. We know that Mr. Smith moved that black backpack inside the house. We know that neither of the people that Mr. Bell saw had a water bottle. And even if you believe that the state proved that my client was the shooter, there's a lot of contradictory evidence, but the shooter never committed the robbery. The evidence is clear that if anyone committed a robbery, it's Mr. Mattei. And there's absolutely nowhere in these instructions that will tell you that you can find Mr. Everett guilty for the actions of Mr. Mattei. You cannot. So without a robbery, there's no felony murder. We know that the water bottle was located, and we know that at least the upstairs neighbor, Mr. Reyes, JJ, who lived at 1704 University Woods Place, provided information about the case. We don't know what that was. We know that Mr. Mattei lived in St. James Apartments nearby. We know that Mr. Everett lived in Polk County and his closest relative was 4 to 5 miles away. Now, clearly the aggravated assault and the other lessers require that multiple conflicting descriptions of the shooter, which cannot be connected to Mr. Everett without bias, without inconsistency, without problems, until the story's changed. Now, there's no question that Mr. Donaldson's death was tragic, senseless, and incredibly emotional. But that does not mean that Kaliyha Everett is guilty. Judge Ward read you the instruction, and you cannot be swayed by emotion. We spoke about that on Tuesday. This case must not be decided by you because you feel sorry for anyone or are angry at anyone. You must not be influenced by bias, prejudice, or sympathy. There's absolutely no unbiased evidence linking Kaliyha Everett to this shooting. There's a pair of pants that don't meet the descriptions. The photographs all have their own individual problems. He can't be linked to DNA on the hat. He can't be linked to DNA on the shoe. And we also heard from at least one of the witnesses that Mr. Mattei's the one who was wearing the slides. And interestingly enough, the pants weren't even looked at or evaluated for any potential blood or any potential DNA until 2017. Mr. Everett exercised a fundamental right by remaining silent, and now is when what we discussed on Tuesday matters. You cannot consider that in any way. Mr. Everett has entered a plea of not guilty, and 5.5 years later, facing a trial for first-degree murder, for which Judge Ward told you he could get a life sentence, his innocence has not been refuted. The state are the ones that have to prove their accusations, as you knew on Tuesday, you know now, and when you have an opportunity to consult your notes, the law, and the evidence, you will know for sure that Kaliyha Everett is not guilty. Thank you.
Mr. Hubbard?
So Andre Smith was familiar with this person, according to what Ms. Beers said. So I guess the question I would ask you, when considering whether that would somehow taint his photo pack ID, isn't that the whole process of a photo pack ID? That's it. Hopefully you learn that through this trial, that when law enforcement show a photo pack to someone, if they are familiar with them because they saw them commit a crime, the hope is that they will pick the right person out of that photo pack. So just because he may have said that he saw him the day before or a week before, does that mean he can never identify that person again? Does that make any sense? He didn't know his name, and again, we know that because no one really used their real name when they were hanging out in this case or prior to this case. So doesn't that further corroborate, and doesn't that further give weight to his photo pack ID? If, in fact, he says he had seen this person, and then he sees them there with Tysaiah Donaldson, that's what he was saying. He said, yeah, under cross-exam, I may have seen him around before this, but he's identifying him, and he told you that he's identifying him not because of 2 weeks before or a month before, but because he's saying that this defendant, Kaliyha Everett, is the one that was there on the night of the offense. So his familiarity would further give weight to his identification of Kaliyha Everett. And I want to clear up, and again, you'll rely on the evidence, but what Ms. Beardsley said about the identification on the bottom of the photo pack. Again, you rely on your recollection, but I submit to you that it's incorrect. Because Deputy Goff testified that when this bottom portion where it says person identified, Kaliyha Everett, that is filled out after the selection is made. And that is filled out by someone, the person who created the photo pack lineup. Again, common sense, law enforcement would be stupid enough to show these instructions to someone and write that the person's already identified before they even made the identification. I think that that's something that would be easy to flush out here in court. Because Deputy Goff testified that the procedure is that that's filled out afterwards. So nobody handed this to Andre Smith. Nobody handed this to Lematarius Matei and said, you know what, I want you to look at these photographs and select Kaliyha Everett. And if you look at the photographs, there's no names on the photographs. So even if that was on there, which I submit to you it wasn't, there's still no way for that person to know the name of each and every one of those individuals unless they are familiar with them or unless they're selecting them because that's the person that they are saying shot and killed Tysaiah Donaldson. And again, it's not just Andre Smith. Because as Ms. Beardsley argues about some of the inconsistencies, again, there were a lot of consistencies with this. And when we talk about inconsistencies and identification, again, use your common sense. When I see someone in public, and I have seen them before, I don't walk up to them and say, you know what, I think I know you because of those shoes you have on. Or I think I know you because I've seen those pants you have on before. Or I think I know you because I've seen you in that shirt before. Or I think I know you because I've seen you wear that Tampa Bay Rays hat or that black beanie. That's not how it works in life. When you see someone that you have seen before, you go up to them and you say, you know what? I think I know you. I know you from somewhere. I've seen you before. I've seen your face before. Think about all the things we use in common sense in everyday life. Think about common phrases like, I'll believe it when I see it. Why do we say that? Because somebody tells us something and you say, you know what, I'll believe it when I see it. Because again, we talked about it in jury selection. You're asked as jurors to be judging a set of facts based on something that you didn't witness. But you're relying on the testimony of people who were there and they saw it with their own eyes. And again, we always use that saying, you know, I'll believe it when I see it. Because when you see something, when you have 10 or 15 minutes to observe someone, when you see that person in a life-altering situation where they pull out a gun, they're pointing the gun at you, they're pointing the gun at your boyfriend, and they pull that trigger and they shoot and they kill that person, that loved one right in front of you, that's something that you don't forget. And people say it all the time. I'll never forget a face, right? Again, common sense, everyday situations. We hear it all the time. People say, I never forget a face. Why is there a saying that goes around in the criminal justice system sometimes, no face, no case? There's songs written about it by rappers. No face, no case, because if no one saw you do it, if no one can identify you in court, then there's no case against you. But when you have three people that come into a court of law under oath and they testify and they pick you out and they say, that's him, whether they point to him here in court or whether they point to him in a photo pack lineup, because you know what? If they hadn't identified him before, and this was the first time you heard from Angelique Major that she pointed to him and identified him, don't you think that that would be a great argument? Well, you're saying this 5 years later. Or you misidentified him and you never picked him out 5 years ago, and now you're saying that that's the guy? That would create some pretty strong reasonable doubt. But that's not what happened in this case. A day later, less than 24 hours had passed when Angelique Major and Andre Smith saw a photograph, whether it was a single photograph without any law enforcement around, without anybody there telling you, hey, this is the person. Because again, it came out that the person that sent it to her wasn't there. They didn't witness any of this. But when they're shown a photo pack, whether it's a lineup or whether it's a single photograph, they believe it when they see it. Because they never forget the face of Kaliyha Everett. And whether they said he had black jeans or slides or a toboggan versus a black knit cap, which is in evidence, they're identifying him based on that face. Because if they can't, no face, no case. But in this case, we have a face. And that face is Kaliyha Everett. One of the other things that came out in testimony just today, I submit to you, is further corroboration. Because again, I'm not going to go back through, but I'll remind you again, when you go back and look at all of these witnesses, Malcolm Bell, Andre Smith, Angelise Major, Letarius Matei, again, look at all the corroboration. None of them ever misidentified anyone. No one ever pointed the finger at someone else other than Mr. Everett. They're all pointing in the same direction. But one of the things that came out today, again, I submit to you for your consideration, is that look at yesterday, Detective Messer testified that the defendant, Kaliyha Everett, was 5'8". And the medical examiner this morning testified that the victim in this case was 5'8". And where was Tysaiah Donaldson shot? Because again, this is evidence other than just the eyewitness testimony that you can use to corroborate and be convinced beyond a reasonable doubt. Because where he is shot is directly right in the sternum. And I submit to you, he's shot directly where someone of the same height would be standing there with a gun. If Tysaiah Donaldson had been 6'2", that person that's 5'8" would be maybe shooting up or looking up at that person, or if that person was significantly shorter. But these two are equal height. They're both 5'8". They're both there face to face. And where is he shot? As someone would reach out a firearm and they would pull the trigger. And as you can see from my arm, and again, there can be many positions that people shoot from, but generally, I would submit to you, common sense, you're shooting right here from your chest area into the chest area of Tysaiah Donaldson. Now, Ms. Beardsley talked about the fact that, well, if you believe that it's Kaliyha Everett, then there's no robbery. But I submit to you again, go back to the testimony, because my recollection of this evidence was that Letarius Matei did testify that Mr. Everett grabbed the water bottle. But one of the other important things is that witnesses said that Letarius Matei was there handling the marijuana. If the defendant's not there, if he doesn't produce a gun, there's no robbery. So he's there with Letarius Matei going over there. The evidence showed that he went over there with him to purchase the marijuana. Whether he held it or whether Letarius Matei held it, even though Letarius says he did grab the water bottle, and the witnesses all said that when this was over, that the marijuana was gone, that they had grabbed it and ran. Without this defendant pulling the gun, there is no robbery. He's the catalyst of this robbery, which then relates to felony murder, because during that robbery, Tysaiah Donaldson is killed. And the last thing I want to leave you with is the pants. Because again, Ms. Beardsley's correct that there was no scientific evidence there at the scene, because law enforcement testified there was no shell casing, and they told you the possible explanation was because this was described as a revolver, which, bingo, there's more coincidences, right? No, that's more corroboration. They're not saying this was a semi-automatic firearm and shell casings were flying out and there's none to be found. That would be weird. But they're all describing a silver revolver, which law enforcement said generally wouldn't leave behind a shell casing. So there's nothing they can collect in that sense. No one ever said that they touched the car. Detective Thomas said that in their investigation, trying to cover all their bases, that they would attempt to fingerprint that or swab it, but no one ever said that they touched it. So she's correct in that sense that there is no scientific evidence there at the scene. But my goodness, just over North 15th Street, just less than a 5-minute walk, just several blocks away from where Tysaiah Donaldson was murdered, there is a pair of pants. And those pair of pants have this defendant's DNA on them. And is it any coincidence that the house at 1211 Fountain Square Place, who lives there? Latarius Matei. Is that all just coincidental? Is Latarius Matei and Malcolm Bell, if they got together after they were interviewed by law enforcement, if they were that savvy that they were determining after the fact that they were going to point the finger at Boosie, Kaliyha Everett, that they would have to somehow go and find a pair of khaki pants somewhere that belonged to this defendant, and they would have to place them at the Fountain Square Place where Latarius Matei said that they ran after the shooting occurred? Or is that scientific evidence that this defendant committed murder and that he's the one that murdered Tysaiah Donaldson? I submit to you that's what it shows you. The pants aren't at the scene because he had them on, because Latarius Matei said he had them on, because Angelise Major said that he had them on. But even though they're not at that scene, as you can see on that map, they're just blocks away. And that is not a coincidence. That evidence, when you look at that evidence and you apply that evidence to the other evidence in this case, which are the multiple identifications of Kaliyha Everett, without hesitation, within 24 hours of Tysaiah Donaldson being murdered, those pants with his DNA cement this case. They are the icing on the cake. Because all of it is evidence that the defendant was the one that committed this murder. That he went to Tysaiah Donaldson on December 30th of 2015, that he pulled that gun, that he shot Tysaiah Donaldson, that he and Latarius Matei took the marijuana in the water bottle, and they ran past Malcolm Bell to the Fountain Square Apartments where he changed clothes, got a ride, and left, leaving behind pants with his DNA that just happened to be several blocks from where Tysaiah Donaldson was murdered. That's all proof beyond a reasonable doubt, and I submit to you that the state has proven this case, that Kaliyha Everett, in this case, is guilty of first-degree felony murder, robbery with a firearm, discharging that firearm, causing the death of Tysaiah Donaldson, and aggravated assault against Angelise Major. Thank you for your time.